That was the moment my brother's lawyer stopped talking mid-sentence. He looked down at the papers in his hands. Then he looked at my brother, then back at the papers. The color drained from his face the way it does when someone realizes they've walked into a room they were not supposed to enter. My brother was still smiling. He thought he'd won. He hadn't. Let me back up, because none of this started in a courtroom. It started the way most family disasters do, quietly, over dinner, with someone asking for a favor that didn't feel like a favor at the time. I was 26 when my grandmother passed. She left behind a 4-unit rental property in Columbus, Ohio, a small brick building she'd owned since the 70s. Nothing glamorous. 2 of the units needed work, the roof was aging, and the property taxes had been delinquent for almost 2 years because she'd been sick and her finances had slipped away from her. But it was hers, and now it was ours. Mine and my brother's, split equally in the will. My brother, he's 8 years older than me, and he has always moved through the world like someone who expects things to work out without much effort on his part. He called me the week after the funeral. "I don't want to deal with it," he said. "The property. You know how I am." I did know how he was. "I'll sign my half over to you," he said. "You always liked that kind of thing anyway." I did like that kind of thing. I'd been taking online courses in property management. I had a spreadsheet already built with projected rental income and repair estimates. I was 26 and I thought I could fix anything if I just made a detailed enough plan. So I said yes. He signed a quitclaim deed. I became the sole owner, and then I got to work. The first year was brutal in the way only people who've owned rental property can understand. The back taxes bill came to just over $11,000. I paid it out of my savings, money I'd been setting aside since my first job at 19. One of the units had a tenant who hadn't paid rent in 4 months and knew exactly how long Ohio's eviction process takes. So I learned. I hired a plumber. I hired an electrician. I replaced the water heater in Unit 3 and discovered the reason it had failed was because the previous tenant had been running an extension cord in a way that was, according to the electrician, genuinely impressive as a fire hazard. I kept records of everything, every receipt, every invoice, every email to every contractor. I'm not naturally organized, but I became organized because I had to be. Over the next 5 years, I stabilized that building. I got all 4 units rented at market rate. I refinanced through a local credit union and used the equity to replace the roof, $18,400. And I remember the exact number because I stared at that invoice for a long time before I signed it. I brought in a property management software system and started tracking everything digitally. By the time I was 31, the building was generating just over $4,200 a month in rental income, and I had turned something that was bleeding money into something that actually worked. My brother called occasionally. "How's the building?" he'd ask, the way people ask about a house plant, casually, with the assumption that it would be fine and that someone else had watered it. "It's good," I'd say. "A lot of work, but good." "Great, great," he'd say. And then he'd talk about whatever else was on his mind. I don't know exactly when his attitude shifted. I think it was gradual, the way resentment usually is. He started bringing up our grandmother more at family gatherings, started telling stories about how close they'd been, how she used to cook his favorite meals, how he was the one who visited her most in her final years. That last part wasn't true, but I didn't say anything. Then, about 2 years ago, the comments started becoming more pointed. He said, at Thanksgiving, in front of our parents and 2 aunts, that he felt he'd been pressured into signing away his share of the property, that he hadn't understood what he was doing, that he'd been grieving and I had taken advantage of that. I remember setting down my fork very carefully. "You called me," I said. "You told me you didn't want to deal with it." "I was grieving," he said. The table got quiet. My mother looked at her plate. My father cleared his throat and said something about the sweet potatoes. I didn't push it. I thought it was just talk, venting, the kind of thing people say when they see someone else succeeding with something they walked away from. It wasn't just talk. 8 months later, I was served with a lawsuit. My brother was suing me for half the property. His claim was that the transfer had been improper, that he hadn't received independent legal counsel before signing, that he'd been in a vulnerable state, that the quitclaim deed didn't reflect a fair exchange. He was asking the court to either award him 50% of the current appraised value, which, after my 5 years of work, had more than doubled, or force a sale of the property and split the proceeds. I sat in my car in the parking lot of my office and read the filing 3 times. Then I called my attorney. Her name is Beverly. She's been in Columbus real estate law for over 20 years, and she has a voice like someone who has heard every possible variation of human foolishness and stopped being surprised by any of it. I like her enormously. Walk me through everything, she said, from the beginning. I did. I told her about the call after the funeral, the quitclaim deed, the back taxes, the 5 years of work, the receipts, the invoices, the software logs. She was quiet for a moment. Do you have all of that documentation? Every bit. Good, she said. This is going to be fine, but I want you to let me handle the strategy here. Don't talk to your brother directly. Don't post anything. Don't even tell your parents the details. What's the strategy? I asked. She paused. I'd like you to trust me on that, Beverly. There's a specific approach I want to take, she said. It depends on the other side not seeing it coming. Just let the process move forward and don't resist the filing. I didn't fully understand what she meant, but I trusted her. What followed was 4 months of the strangest legal experience of my life. My brother's attorney, a man named something forgettable, which I appreciate in retrospect, sent a series of increasingly confident letters. They outlined their theory of the case. They cited case law about undue influence. They requested documentation I was happy to provide, because every document I provided showed exactly how much work I had done and how little my brother had contributed. I watched his lawyer build his confidence letter by letter. Each response from Beverly was measured, calm, and gave away nothing about where she was going. My brother texted me once during this period. I don't want this to be a big thing, he wrote. I just think what happened wasn't fair. I looked at the text for a long time. I thought about the $11,000 in back taxes I had paid, the $18,400 roof, the eviction proceedings, the Saturday mornings I spent driving to the hardware store, the spreadsheets, the tenant calls at 11 p.m. because the heating unit in Unit 2 was making a sound like a dying animal, the refinancing, the property management software I taught myself to use by watching YouTube tutorials in my car during lunch breaks. I did not text him back. The hearing was scheduled for a Tuesday morning in March. The night before, Beverly called me. I need you to understand what's going to happen tomorrow, she said. I need you to be comfortable with it, because it's going to feel wrong at first. Okay, I said. I'm going to concede the transfer question. What? I'm going to agree that the process could have been cleaner, that he might have benefited from independent counsel. I'm going to suggest that we're not here to fight about what happened 6 years ago. Beverly, he's going to think he's winning. Yes, she said, he is. There was something in her voice that made me stop pushing. What happens after that? I asked. After that, she said, his attorney is going to discover exactly what he's asking for. The courtroom was smaller than I expected. Wood-paneled, fluorescent lighting, the particular smell of a government building that has been cleaned with the same product for 30 years. My brother sat across the aisle with his attorney. He looked relaxed. He caught my eye once and gave me a look I recognized from childhood. The slight tilt of the head that meant he thought he had the upper hand. Beverly stood and delivered exactly what she'd described. She was gracious about it, acknowledged the emotional circumstances of the transfer, said I wasn't there to dispute the relationship my brother had with our grandmother, said we were open to the court's guidance on a resolution. My brother's attorney looked like a man who had prepared for a fight and just been told the other side wanted to negotiate. He straightened up. He got a little expansive. He began outlining what his client was owed. Beverly waited. He got to the part about the current appraised value of the property, $387,000 and proposed that my brother receive half either through buyout or forced sale. Beverly said quietly, "We have no objection to the property transfer." I heard my brother exhale, and then Beverly said, "We'd simply like to ensure that the court documents reflect the full ownership obligations attached to the property, and that my client is formally released from those obligations at the time of transfer." My brother's attorney looked at her. "What obligations?" Beverly set a document on the table. The roof was replaced in 2022 under a financing arrangement with Midwest Lending Partners. The outstanding balance is $11,200. The property also carries deferred maintenance reserves required under the current rental license, approximately $8,500 documented here. Additionally, the property management agreement my client signed includes a personal guarantee clause that would transfer with ownership. That clause requires the owner to maintain a minimum 90-day operating reserve of $12,600 at all times, or face a penalty structure outlined on page 4. She turned to page 4. "We're happy to transfer the property," she said. "We just want to make sure everyone understands what's being transferred." The room was quiet. I watched my brother's attorney read the document. I watched him flip to page 4. I watched him flip back. I watched him look at the roof financing agreement. I watched him look at the rental license reserve requirement. I watched the color leave his face. He asked for a recess. In the hallway, I could hear my brother's voice, though not the words, sharp and questioning. His attorney's voice was lower, slower, the voice of someone explaining something that cannot be explained pleasantly. Beverly stood next to me with her coffee cup and said nothing. She didn't need to. When they came back, the energy in the room had changed entirely. My brother's attorney requested a conference with the judge. What followed was a 40-minute conversation that I was not part of, during which, Beverly told me later, his attorney acknowledged that his client had not been aware of the financial obligations attached to the property and needed time to assess whether the transfer was still in his client's interest. 6 years ago, my brother had walked away from this property because he didn't want to deal with it. He had watched me deal with it for 6 years. He had decided at the moment it was worth something that he wanted back in. He had not thought about what "in" actually meant. The case was eventually settled outside of court. My brother withdrew the lawsuit. In exchange, I agreed to formally document the original transfer with proper legal review, something Beverly said we could do easily, and that would actually protect me from any future claims. It cost me $800 in legal fees and an afternoon. He got nothing, no equity, no buyout, no share of the rental income he'd never helped earn. We haven't spoken since the hearing. I don't know if we will. Part of me is still sad about that. The part that remembers being kids, that remembers him teaching me to ride a bike in the parking lot behind our parents' house, that remembers calling him the first time I was really scared about something and he picked up on the first ring. But I also remember sitting in my car in that office parking lot, reading a lawsuit from my own brother, and feeling something I can only describe as a door closing. I didn't close it. He did. And sometimes you have to let people close the doors they choose to close. People ask me sometimes what I would have done differently. Honestly, not much. I would have made sure the original transfer had cleaner documentation from the start. Beverly has been very clear that a quitclaim deed without independent counsel for both parties is a vulnerability, even when everyone's acting in good faith. A few $100s at the outset could have prevented years of stress. I also would have kept more emotional distance from the building. I cared about it the way you care about something you've built, which is deeply and sometimes irrationally. When my brother filed that lawsuit, it felt like more than a legal claim. It felt like someone trying to take credit for work they'd refused to do. But here's what I've learned about property and about people. Ownership isn't a title. It's not a name on a deed. It's the Saturday mornings. It's the 11 p.m. phone calls. It's the spreadsheets and the receipts and the months you spend learning things you never expected to learn because the thing you're responsible for needs you too. My brother wanted the reward without the record of what it took to get there. The law, as it turns out, keeps very good records. The roof doesn't care whose name is on the deed. The operating reserve doesn't care about feelings at Thanksgiving. The financing agreement doesn't care about childhood memories or who visited grandma more in her final months. It only cares about who showed up and did the work. That was me, and on a Tuesday morning in March, in a wood-paneled courtroom that smelled like industrial cleaner, a piece of paper said so.